Very good morning to everyone who's joined this webinar. Thank you very much indeed. It's hosted by Landmark Chambers. My name is Matthew Fraser and I'm joined by Heather Sargent for a recap of the key planning cases of 2020. If anyone's into Charlie Brooker's annual screen wipe or watched his recent documentary Death to 2020, we're basically doing that but for planning law jurisprudence. And it's been an incredibly mad year in many ways for lots of people. And I think Heather and I have found it quite a challenge to fill it through the huge number of judgments that have been coming out from the Planning Court, the Court of Appeal, the Supreme Court, that have been handed down in the last year, to try and find the select few to talk about for the next 45 minutes, but we think we've come up with a reasonable selection. What we're going to do is we're going to alternate as we go through. And feel free, of course, to ask any questions that you've got in the Q&A box at the top or the bottom of your screen, and we'll try and answer them if we've got time and if we know the answer. A few other housekeeping points just before we begin. Your microphones are automatically muted, so you don't need to adjust your local settings. And also the webinar is being recorded, so you'll receive a link to the presentation and the recording as soon as the webinar is concluded. And if your connection is lost at any point, then we invite you to rejoin the meeting by clicking on the original link once more. So let's get underway. If I could have the first slide, please. It would be impossible to do a recap of 2020 without including the Supreme Court's judgment on the lawfulness of the national policy statement for a third runway at Heathrow Airport. This statement has been in the throes of litigation for the past 2.5 years since it was designated in June 2018. You may remember that in 2019, the Court of Appeal held that the Secretary of State, represented by a team of barristers at Landmark, including Heather, acted unlawfully in failing to take the Paris Agreement on climate change into account in designating the statement. And although the Secretary of State did not appeal, the owner of Heathrow Airport did, and the Supreme Court unanimously allowed the appeal. There's a statutory requirement in the Planning Act 2008 to explain how the national policy statement takes into account existing government policy on climate change, and the judges held that this did not extend to the ratification of the Paris Agreement or certain statements that have been made about the Paris Agreement by government ministers at different times. And the judges concluded that there was no such government policy for the purposes of the Planning Act 2008 beyond that was already contained in the Climate Change Act of 2008. And similarly, the court rejected the argument that the government had failed to have proper regard to the Paris Agreement in the context of their duty to contribute to sustainable development. And I think the real root of this conclusion was the requirement in the NPS itself, that when Heathrow eventually apply for development consent for the third runway, they're going to, at that stage, need to demonstrate up-to-date compatibility with the Paris Agreement and the Climate Change Act 2008, as well as any other environmental policies at play. And the last point, just to note about the Heathrow case, is that the court held that there was no breach of the Strategic Environmental Assessment Directive. This directive requires the production of an environmental report, and the court noted that an unduly legalistic approach should not be taken when assessing the adequacy of an environmental report published under the SEA rules, given that it's merely intended to provide a basis for informed public consultation on the proposal. And the content of such reports is the subject of a discretion, and the exercise of that discretion can only be challenged on the usual public law grounds of irrationality and such like. And it was enough in this particular case that the report referred to the Climate Change Act targets themselves, and there was no further need to specifically deal with the Paris Agreement. So that's our first case, the Heathrow case, and I'll now hand over to Heather to introduce the second case.
Thanks, Matthew. So Hillside is a case that I'm sure lots of you are already very familiar with, a decision of the Court of Appeal from November last year, Lord Justice Singh, Nicola Davis and David Richards agreeing with him. I think if I had to pick the case from 2020 that's generated the most uncertainty, this would definitely be somewhere on the shortlist and probably pretty high up, to be honest. Also would be on my list of cases that are likely to cause headaches in 2021. I've put on the slide the end of the drop-in application ? Because some commentators are suggesting that that is the effect of Lord Justice Singh's judgment. But just to recap the facts quickly, planning permission was granted back in 1967 for 401, I think, houses at Aberdyfi in Mid Wales, and the planning permission incorporated a master plan. There were then a whole series of planning permissions for departures from the master plan granted from 1967 itself onwards. There was a High Court case in 1987, which I don't have time to go into, but if anyone's interested, note that it gives rise to a big debate about res judicata and similar issues. And planning permissions for departures from the master plan continue to be granted all the way through the 90s and the noughties up until 2011. But then in 2017, the local planning authority said that the 1967 planning permission could no longer be implemented because the developments carried out in accordance with the later planning permissions had rendered it impossible to implement the original master plan, because of inconsistent development in parts of the site. Pursuant to the later departure planning permissions, it wasn't physically possible to build out the 1967 scheme in its entirety. So it will be obvious to many of you, if you haven't already come across Hillside, that we're dealing with well-known case laws, so Pilkington, the Pioneer Aggregates case. The Court of Appeal in Hillside concludes that the High Court was perfectly entitled to conclude that the 1967 planning permission could no longer be implemented. But what has caused particular consternation is Lord Justice Singh's observation that the 2003 decision of the House of Lords in the Sage case has placed greater emphasis, he says, on the need for a planning permission to be construed as a whole, and that it has become clearer than it was before 2003 that a planning permission needs to be implemented in full. So why exactly are people concerned about Hillside? Well, Sage concerned a grant of planning permission for a single dwelling house, yet the Court of Appeal in Hillside does seem to think that the requirement of a holistic approach applies equally to planning permissions for much larger developments, such as the 400 houses in Hillside. And it seems to me that the Court of Appeal does apparently reject a suggestion that Sage is only relevant where the planning permission is for a single operation, such as perhaps the erection of a single dwelling house, because the Court of Appeal in Hillside accepts what it describes as the fundamental submission that Sage made it clearer than it had previously been that a planning permission should be construed holistically. And the other aspect of Hillside that's potentially difficult is that the Court of Appeal endorses the approach taken by Mr. Justice Hickenbottom, as he then was in the Singh case. And again, Singh concerns a very small scale residential context of a couple of dwelling houses. But the judge held there that where parts of a development are physically incapable of being completed because intervening development has been carried out pursuant to a later planning permission, then the whole development becomes unlawful. Unhelpfully, to be frank, the Court of Appeal in Hillside, because it wasn't really relevant on the facts, has left open the question of what happens where you have a scheme that's permitted by a first planning permission that is partially built out, but then development is undertaken pursuant to a second planning permission, and so the scheme can't be built out to completion fully in accordance with the first planning permission. The question is, in that circumstance, is it only any development undertaken after the intervening development under the second planning permission that will be unlawful, or is the effect of intervening development under a second planning permission to render the development that's already been carried out under the first planning permission unlawful simply because it can't be completed fully in accordance with the first planning permission? The Court of Appeal expressed no view on that, so the courts will have to come back to that one, and I suspect they might be doing it sooner rather than later. My view is that actually I think both Sage and Singh do lead to the conclusion that it's all of the development carried out under the first planning permission both before and after the intervention of the second planning permission, that will be unlawful. I appreciate that that's not a popular analysis, but I do think that's what the judgments are saying. The final aspect of Hillside is that the Court of Appeal addresses the Lucas case from 1964. And in Lucas, the judge had held that a planning permission for 28 houses in a cul-de-sac layout did actually authorise the partial development of that scheme in circumstances where part of the site had been built out under a later planning permission and had then become unavailable. But the Court of Appeal in Hillside says that Hillside isn't a Lucas case, and whilst it doesn't overrule Lucas, it says that it should be regarded as having been decided on its own facts. And Lord Justice Singh says that it's unlikely, in his view, that the correct construction of a typical modern planning permission for the development of a large estate, such as a housing estate, is that it permits the development to take place in a series of independent acts. Now, Lord Justice Singh seems to be worried about the developer cherry-picking bits of the scheme for development, so building out some of the houses but leaving out things like highways, landscaping, and perhaps building schools or GP surgeries. Taking that last point first, I don't think the cherry-picking fear is particularly well-founded, because if the conditions to the planning permissions are properly drafted, then they should be able to ensure that you can't bring forward your houses without sorting out your highways, your landscaping, your school or your GP surgery beforehand. I do think that Hillside potentially makes drop-in applications difficult. If Sage and Singh is to apply to large schemes rather than Lucas, actually I think the difficulty isn't just Hillside, it's a combination of Hillside and the Court of Appeal decision in Finney. Because the route for drop-in applications post-Hillside, if we leave Finney to one side, would be, I think, to make sure that alongside your drop-in application, you obtain a Section 73 planning permission that in effect varies the original scheme planning permission, for example, by carving out the site of the drop-in application from the approved plans. And I wonder whether, if you had a retrospective Section 73 planning permission, that might even be an answer to the point that's being left open in Hillside about the effect of Singh. But Finney, which I was going to come back to later, but we might as well pick it up now. Finney in the Court of Appeal establishes that Section 73 can't be used to impose a condition that alters the nature of the development permitted under the original planning permission, and the local planning authority can't change the description of the development in the original planning permission either under Section 73. And last year, the Supreme Court refused permission for Finney, so those points aren't up for debate anymore. So I think past a point, it might well be difficult to get the drop-in application plus Section 73 permission combination to work. So we'll have to see what the courts make of Hillside in due course. A final caveat on Hillside, though, is that Sage and Singh both distinguish between what they refer to as final planning permissions and outline planning permissions. The 1967 planning permission in Hillside wasn't an outline planning permission, so I tend to think that actually none of this analysis affects outline planning permission, and certainly in my view there's at least an argument that it doesn't. So that's Hillside. I promise that I won't spend as long discussing the other cases that I'm going to talk about, but there's quite a lot to unpick in that one. And I'll hand back to you, Matthew.
Before we finish on Hillside, do you happen to know whether either of the parties have applied for permission to appeal from the Supreme Court on Hillside? Or?
Not as far as Google would tell me. I'm sure there's somebody listening in who probably has a far better idea of that than I do. So if they want to let us know, that would be great.
If someone wants to enlighten us, if they know, then it's. I think you're completely right, Heather, that it's both an extremely significant judgment and also a troubling judgment, I think, for a lot of practitioners trying to work out how it's meant to play out in practice. Okay, so we'll just go on to the next slide now, if that's all right. This is the next case, the Sam Smith case. It's another Supreme Court decision, and this case is all about the meaning of the word openness in national greenbelt policy. I'm sure it's a concept which is of great familiarity to everyone listening in. What does it mean for development to preserve the openness of the greenbelt? That's the question, and the development at issue in this case was a quarry extension And in deciding to grant planning permission, the authority had considered the landscape impacts of the scheme in the context of openness, but they hadn't considered the visual impacts in the context of openness. The High Court said that there was nothing wrong with that. That was okay. The Court of Appeal disagreed, and the Supreme Court unanimously allowed the appeal, so restored the judgment of the High Court, holding that visual impacts are not, in fact, an essential part of an assessment of the impact on openness, and that in this particular case, the relatively limited visual impacts fell far short, that's what Lord Carnwath said, far short of being so obviously material that a failure to address them would be an error of law. And the matters relevant to openness in any particular given case are, the judge said, matters of planning judgment and not law. And just for those who are particularly interested in case law relating to the concept of openness, see also the Liverpool Open and Green Spaces Court of Appeal judgment recently. And this is where the Court of Appeal comes at it from a different perspective, because they're looking at the concept of openness in a local green wedge policy as opposed to the national policy. And it's also a very interesting recent decision on heritage impact. So that's the Sam Smith case, and I'll now pass back over to Heather for the next one.
Thanks, Matthew. If we can get the next slide up, please. But we're moving on to look now at heritage and the Supreme Court decision in Dill from May last year. I'm sure this is already firmly on the radar of everyone who's got a particular interest in listed buildings. But Dill is concerned with a pair of 18th century lead urns that apparently originally flanked the entrance to the gardens at Rest Park in Bedfordshire. The urns were then moved to different properties several times between the late 1930s and the 1970s, and they ended up in the gardens of a house somewhere in Warwickshire that was Grade 2 listed. That was in 1966, but then in 1986, the urns and the limestone piers or pedestals on which they stood were separately, independently listed. Worth noting that the piers weren't fixed to the ground and the urns weren't fixed to the piers. And the urns were then sold at auction in 2009 for £55,000. And after that, it seemed that they ended up overseas. So in 2016, the local planning authority issued a listed building enforcement notice against the removal of the urns. And Mr. Dill, who, to be fair, hadn't appreciated when the urns left him and went overseas that he'd done anything wrong, appealed against the enforcement notice. And his argument was that the urns and the piers weren't buildings, but the inspector concluded that the status of the items as buildings was established by the fact that they were listed as listed buildings, and he couldn't go behind that. The High Court and the Court of Appeal upheld the view that the status of items as buildings wasn't open to challenge on appeal, and the Court of Appeal held that the intention of the Listed Buildings Act was that for the purposes of applications for listed building consent, for enforcement and for appeals, inclusion on the statutory list was determinative of the status of the item as a listed building. So if it's a listed building, and you can't argue about that subsequently. That was the Court of Appeal's view. The Supreme Court last year, though, overturned the Court of Appeal and confirmed that an inspector considering an appeal under Section 20 or Section 39 of the Listed Buildings Act can consider whether or not something on the statutory list is actually a building. There's only one judgment from Lord Carnwath, with everyone else agreeing, and he points out that, potentially an obvious point, but he says that a listed building is a building that's included in the statutory list. So if it's not actually a building at all, then it can't become one just by being included in the list, which, to be honest, seems fair enough to me as analysis goes. He also notes that in a planning enforcement appeal, as compared to a listed building enforcement appeal, it can be argued that a particular structure does or does not constitute a building. So why should it be any different in the listed building context? He reasons as well that where criminal proceedings are brought for contravention of the provisions of the Act, it has to be open to the accused to argue that an item on the statutory list is not a building and therefore not a listed building under the Act, particularly because contravention of listed building control is a criminal offence whether or not an enforcement notice is served. And he carried on to reason that similarly under section 39 of the Act, where you're appealing against a listed building enforcement notice, the appellant can argue that the matters alleged to constitute a contravention of the Act don't actually constitute such a contravention. So again, in Lord Carnwath's view, that must mean that the appellant has to be able to take the point that the relevant item isn't a building. And if the appellant were to succeed in arguing that a listed building is not actually a building, then the Secretary of State could cancel the listing and remove the item from the list. Lord Carnwath queries whether that cancellation would operate retrospectively. But his view is that the clear implication of the listing being cancelled would be that the item should never have been listed in the first place because it's not a building. So that should protect the owner from any further action. The other aspect of DIL is that the Supreme Court carries on and considers what criteria are relevant in determining whether an item that appears in its own right in the statutory list, as opposed to being what's often referred to as curtilage listed, is actually a building. At this point, reading through the judgment, both times that I've done it, I got really distracted by the discussion of various garden structures, because apparently the 27 life-size dinosaurs at Crystal Palace, which I confess I've never actually visited, but I'm sure they're great. And apparently they're grade 1 listed, which I didn't know, so I might go and see them once lockdown lists. Lord Carnwath confirms that the Skerritt's criteria for identifying a building for the purposes of the Town and Country Planning Act, as opposed to the Listed Building Act, are relevant in the listed buildings context. So it's consideration of size, permanence, and degree of physical attachment to the land. I mentioned that the urns and the piers in DIL weren't attached to the land. The Supreme Court doesn't actually come to a conclusion in the judgment as to whether those items actually are buildings or not. There's a rejection by the Supreme Court of the argument that property law concepts, so the extent and purpose of a structure's annexation, govern the basic definition of what is a building, and the Supreme Court saw no reason to import those contexts into the basic definition, although it does say that those concepts are relevant to the extended definition, so the curtilage listing aspect of the legislation. So that's DIL. I think we are having a bit of difficulty with the slides, but if we're able to move on to the next one, I'll pass back to Matthew.
Thanks very much, Heather. And yeah, just on DIL, as your example of the list of buildings reminded me that there's another one which is probably going to have to be delisted as a result of DIL, which is the zebra crossing on Abbey Road, which has been designated as a listed building because of the Beatles album cover, and I think I can't see how that can possibly survive the Skerritt's test. And I think just another interesting observation to make on DIL is that although Lord Carnwath is talking about the context of a criminal prosecution for breach of a listed building enforcement notice or an appeal against one, I personally can't see any reason in principle why the question of whether a building should be a listed building shouldn't arise also in the context of an application for planning permission. An ordinary application for planning permission, the local planning authority have to decide on the impact, and if a listed building that is potentially being impacted shouldn't actually be listed, then I can't see any reason why the local planning authority shouldn't be able to apply DIL and consider that. I don't know whether you have any thoughts on that, Heather.
I mean, I think that's what's particularly helpful about the sort of Skerritt's aspect of the judgment in DIL, in that at least that is a test that lots of local planning authorities have at least had, some dealings with. Skerritt's itself was about a marquee. I've come across it in similar situations too. So I think it is helpful that the Supreme Court has kind of just applied the Town and Country Planning Act approach rather than wandering off into kind of private property law concepts, which would be less familiar to local planning authorities having to grapple with this.
Indeed, yeah, and indeed to the planning barristers advising them. Good. Well, let's move on to the next case. This is, you kind of get actually it's the previous case. Yeah, that's the one, Airborough. You really get 3 for the price of 1 with this case, because it ended up being 3 different judgments. The first arose because there was a point taken that the claimants, the Airborough Neighbourhood Development Forum, didn't in fact have legal capacity to bring proceedings. And so there was a judgment by Mrs. Justice Leven, who gave all 3 of the judgments holding that they do. So it's quite an important outcome. It's something that has been the subject of some dispute for a while, that an unincorporated association, despite not being a legal person, can in fact bring public law proceedings. There's then the second judgment, which is the substantive challenge itself, dealing with the lawfulness of the Leeds site allocations plan that had been adopted by the City Council, and then a third judgment dealing with remedy, which in many ways is actually the most interesting judgment, because deciding what to do about an element of unlawfulness in a local plan that's been identified by the High Court can result in some really difficult issues as to what to do about that. Do you just quash the plan? Do you remit the plan back to a stage of the examination? If so, what stage? If so, what are the directions that the court needs to give to the inspector and the local planning authority to redetermine and readopt the plan? So it's a really difficult issue. But this particular case was all about a challenge under Section 113 to the Leeds site allocations plan. It contained a number of greenbelt housing allocations, and they were justified on the basis of exceptional circumstances, as they needed to be. And those circumstances included, as it often does, significant housing need in the area. And while the plan was under examination, a significantly lower housing requirement was emerging at the same time. And this was using the new methodology, and this new requirement slightly pulled the rug from underneath the justification for the same extent of the greenbelt releases. And the court held that the inspectors examining the plan had failed to deal with the consequences of this emerging housing need change, and had failed to give adequate reasons why there were still exceptional circumstances for the greenbelt release, whether they still existed. So that's the Airborough case, and it really comes. It's quite interesting, like looking through the judgments of the last year, and actually even going into 2019 as well. I couldn't help but notice that there's been quite a large number of local plan challenges going through the courts in recent times. I'm thinking of the recent Sevenoaks decision and Harrogate, two recently successful challenges to identify unlawfulness in the plan, alongside Airborough and Leeds, of course. And then recent unsuccessful challenges have included the Guildford plan, Wycombe's local plan, and the Waverley case as well. So it's been an interesting time for local plan challenges, and I suspect we'll be seeing a few more of them in 2021. And I'll pass back to Heather for the next case.
Thanks, Matthew. Yeah, I was involved in the Guildford local plan challenge actually, and when I came to put my list of suggested cases together, I was convinced that we'd had judgment on that last year, but it must have been a really long year, because it was indeed 2019. But I think that judgment's actually particularly helpful in terms of analysing exceptional circumstances and what you actually need to pass that threshold. I think it's brought some kind of additional clarity to the previous case law on that. Moving on then to Norfolk Homes, this is a decision of Mr Justice Holgate from August last year, and really serves, I think, as a warning to local planning authorities. It's concerned with Section 106 obligations, and what happened was that in 2012, outline planning permission was granted for 85 houses subject to a Section 106 agreement that, amongst other things, secured 45% affordable housing. There were then Section 73 planning permissions granted in 2013 and again in 2015, both using the 2012 planning permission as the base planning permission, but neither Section 73 planning permission was contingent on the prior execution of any further Section 106 obligation, and in particular there wasn't a Section 106 obligation that imposed the same requirements as the 2012 Section 106. By the time of the hearing, both the 2012 and the 2013 planning permissions had lapsed, actually, so that only the 2015 planning permission was still in play. The first point from the judgment, just in case it's relevant to anyone who's watching, is that Holgate says that you can't use a lawful development certificate granted under Section 191 or 192 of the 1990 Act to establish whether a planning permission can lawfully be implemented without triggering landowners' obligations under Section 106. Those two sections, 191 and 192, don't enable the legal effect of non-compliance with a Section 106 to be tested, because Section 106 is a freestanding legal instrument. It doesn't form part of any grant of planning permission, in contrast to planning conditions. And Mr. Justice Holgate emphasises that point a lot in the course of the judgment. The main issue in the case, though, was whether the 2012 Section 106 applied to the 2015 Section 73 planning permission. And the local planning authority argued that the definition of the terms development and planning permission in the Section 106 should be read as including any subsequent Section 73 planning permissions, including, unsurprisingly, the 2015 Section 73 permission. Mr. Justice Holgate cites both Trump and Lambeth from the Supreme Court and holds that there is no reason why statements in those two cases on interpretation shouldn't apply to a Section 106 obligation. And in his view, that is whether the Section 106 is unilateral or an agreement. Mr. Justice Holgate's view is that Trump makes it plain that a distinction that was suggested by the local planning authority between principles of interpretation applying to contractual documents and planning documents is fallacious, and the general principles on the interpretation of legal documents, so cases like Investors' Compensation Scheme, which anyone who looked at contract law as a student might remember, those general principles are applicable to Section 106 obligations, whether unilateral or bilateral. That's the Robert Hitchens case. And in Mr. Justice Holgate's view, there's nothing in Lambeth from the Supreme Court that alters the standard principles of construction for public documents. So on the facts, because the key terms in the Section 106 were defined by reference to the 2012 Planning Permission, they had the clear effect, says Mr. Justice Holgate, of limiting the triggering of obligations under the 2012 Section 106 to the carrying out of development under the 2012 Planning Permission and not any later Section 73 Planning Permission. And Mr. Justice Holgate's point was that the parties to the Section 106 could have chosen to word it differently so as to encompass later Section 73 Planning Permissions, but they didn't. And amongst other things, for that reason, Mr. Justice Holgate went on to decline to imply additional words into the 2012 Section 106 because he took the view that the parties had drafted it so as to avoid its application to later Section 73 planning permissions, so it wouldn't be reasonable to imply wording in. So overall, the 2012 Section 106 had ceased to have effect and didn't apply to the later Section 73 permission. So the short point to take away from Norfolk Homes is that if you're drafting a Section 106 and you want it to apply in future to grants under Section 73, then you need to be really careful about how you word it to avoid the outcome in Norfolk Homes.
Thanks, Heather. Yeah, it's a really interesting judgment, Norfolk Homes, and I've already, I don't know about you, but I've certainly already had one set of instructions asking to advise on whether the case can be applied to another set of facts, and it's I think it would be of great interest to a lot of people wondering whether they have Norfolk type facts for their Section 106 and their Section 73. There's just a quick update before we go to the next case on Hillside. We've been very helpfully informed that there is indeed an extant application for permission to appeal in Hillside from the Supreme Court, so that may not be the last word on Hillside. And there's also been a question asked about whether Hillside imperils bringing forward temporary or meanwhile uses on plots within multi-phase schemes that would otherwise be lying vacant for a number of years. I think it's a really good question. My own view would be that it wouldn't imperil such uses, because coming up with a temporary use, authorising a temporary use pending the implementation of the bigger multi-phase consent would be entirely consistent with that multi-phase consent. So you could have a completely freestanding temporal permission for something in the interim period that would not be inconsistent or frustrating or changing anything about the multi-phase scheme that has been granted permission. I don't know whether you've got any thoughts on that, Heather.
No, I agree with you on that, Matthew. Yeah.
Good, good. And then just one quick thing on Dill as well. We've had a very interesting point made by another viewer who says that a number of post boxes, telephone kiosks, and wall memorials also have currently listed status. So there's definitely a question mark over those structures as well, to see whether they would satisfy the Skerritt's test. So we'll turn on to the next slide if I can. This is the case of Peel, and what can we say about Peel? Well, remember, I was in this case representing Salford, the second respondent in the Court of Appeal, and if anyone remembers, I'm sure there will be lots of people who remember it, the paragraph in Lord Carnwath's judgment in Suffolk Coastal, I think it's paragraph 63, where he says that a plan that carries on beyond its plan period is out of date in any event, and lots of people got terribly excited about this obiter remark by Lord Carnwath in the context of Suffolk Coastal. And the appellants in this case, the Peel case, relied on this remark from Lord Carnwath in order to argue that the expiry of the specified period of a development plan renders in all of the policies in that document automatically out of date for the purposes of paragraph 11D of the NPPF, thereby triggering the tilted balance, which may strike many as a slightly alarming consequence, because of course there are lots of plans up and down the country which have gone past their specified plan period. Anyway, the Court of Appeal upheld the High Court's decision and said that this wasn't in fact the correct approach to paragraph 11D in the meaning of out of date, and the remark made by Lord Carnwath was indeed obiter, and it wasn't seeking to deal with the concept of out of date or outdatedness for the purposes of the NPPF and that particular paragraph. So instead, what you need to do in applying the question of datedness is to look at whether the policies in question have been overtaken by things that have happened on the ground since adoption, or indeed through a change of national policy, and that's the test that was established by Mr. Justice Lindblom in Norwich Homes, as he then was, and it is indeed the established test as a consequence of the Court of Appeal's judgment in Peel. The court also held that an old plan, even if the strategic housing policies in that plan have not been saved, is not automatically out of date for that reason either. And one needs to, for example, if you're looking at the datedness of an environmental protection policy, like a green wedge policy or something like that, it may be that those policies will not expire with the plan period, but survive well beyond it, because they're not intended to be coterminous with the end of the plan period. Just to note, for those with a particular keenness for paragraph 11D, you will not have failed to notice that it has been the subject of a spate of cases about this particular vexed paragraph of the NPPF. And just to mention a few of them, Gladman, this is whether you can take development plan policies into account in applying the tilted balance. Oxton Farm, this is about the approach. This is also about the approach to whether policies are out of date. Paul Newman Homes, this came out of the Court of Appeal last week, so it's actually illegal for us to talk about it because this is a recap of 2020. But this is a 2021 judgment, and that's all about the operation of the two triggers in paragraph 11D. And last but not least, Monkhill is the case that I'm in. The Court of Appeal judgment on this matter is pending. Argument was heard in November 2020, and this is all about what it means for a paragraph in the NPPF to provide a clear reason for refusal for the purposes of 11D. So that's one to watch. I suspect it'll be coming out as soon as Lord Justice Lindblom can get round to writing the judgment. Then we'll be getting an answer in Monkhill. So that's Peel and related cases. I'll pass back to Heather for I think the last main case that we're going to be talking about.
Thanks, Matthew. Yeah, and before I move on to rights community action, we just had a query in on Norfolk Homes asking, do we know why the local planning authority didn't simply enter into a supplemental deed to link the existing section 106 to the new section 73 permission? The short answer to which is no, I don't know. It's not revealed in the judgment, but I had been wondering that myself. So again, if anyone listening in has any light to shed on that, then do feel free to let us know. If we could just, there we are, have the slide up for rights community action. This is the challenge to the statutory instruments that amended the GPDO and the use classes order back in August and September last year. So the statutory instruments enabling the construction of 1 or 2 additional stories as permitted development in certain circumstances, enabling demolition and rebuild for residential use, again under PD rights in certain circumstances, and of course introducing Class E into the use classes order. The challenge was dismissed by the Divisional Court in November. The claimant brought 3 grounds of challenge. First, an alleged failure to carry out strategic environmental assessment, SEA. Secondly, only against the statutory instruments that amended the GPDO, not the one amending the use classes order, an argument that the Secretary of State had failed to have due regard to the public sector equality duty. And then against all 3 statutory instruments, an allegation that there had been a failure properly to consider consultation responses, a failure to take into account the advice of the government's own experts, inconsistency as regards the previous approach to PD reforms, and a failure to reconsult on the demolition and rebuild PD right. All of that was considered at a rolled up hearing. On SEA, the use classes order, SI in the court's view, simply defined whether certain changes of use constitute development for the purposes of development control, and the court said that such a legal measure didn't set the framework for the grant of future development consents. In fact, by definition, it did no such thing. The court went on to hold that the 2 permitted development statutory instruments didn't set the framework for the grant of future planning consents either, because they are the measure by which planning permission for defined development is granted. So another example in domestic law of legal measures not requiring SEA because they don't set the framework for the grant of future development. That issue has been litigated a number of times now. On ground 2, public sector equality duty, the argument received short shrift on the facts and was dismissed as unarguable. On that, I would say that I think we're increasingly seeing public sector equality duty arguments form the basis for a ground of challenge against planning and environmental decisions. But my experience anyway is that it generally remains quite difficult to succeed with an argument. I think it has been done, but or at least arguments have passed the permission threshold, but I've certainly attempted arguments and not succeeded myself before now. So I guess it's good to see that I'm not the only one. On the 3rd and final ground, one point to note here is that the Divisional Court held that there were good reasons for MHCLG departing from its promise of a second consultation on the demolition and rebuild PD rights proposal. The good reason was the pandemic. The government had decided to grant the PD rights, so the court decided in order to stimulate regeneration at a time of great economic difficulty, and the court thought that that was good reason to decide in favour of urgent action as opposed to further consultation. So worth having a look at this decision if either already or in due course, you were promised something that then has been disrupted by the authority having to deal with the pandemic. So that's a very brief tour through the debate in rights community action about over the statutory instruments. And I think if we can move on to the next slide. We've just got a very quick roundup in the minute of this presentation that we don't have left of 4 other cases to note. The first one is Burton Genie. I don't have anything to add to what I've put on the slide here. The relevance of this decision is that an interested party does have standing to apply for a variation to the Aarhus Convention cost limit. What I would add is that the Court of Appeal, which is still, well, until recently has still been considering its Heathrow judgment, very recently held, I think on the 13th of January or thereabouts, that Aarhus Convention cost limits are inclusive of VAT. So you can't recover VAT on top of your £5, £10 or £35,000. And Finney, I've put the citation there, but I don't need to go back over that because we looked at it when we were thinking about Hillside earlier. So Matthew, I'll let you talk about Gluck and London Historic Parks, I think.
Thanks, Heather. Yeah, just very quick mention, not honourable mention for these two cases that didn't make it onto the list of main cases to talk about. But Gluck was a judgment of the Court of Appeal handed down just before Christmas, and it's really just confirming the High Court's decision below that the 56-day period for determining prior approval applications in the GPDO can be extended by agreement. That agreement needs to be evidenced in writing between an applicant and the local planning authority. And the London Historic Parks and Gardens Trust, really interesting case. We really should, you could have a whole webinar just on this case, to be honest. It's a JR claim against the handling arrangements for determining the Secretary of State's own planning application for the Holocaust Memorial. There was an argument that the UK had failed to adequately transpose the requirements in the EIA directive for independence and objectivity when carrying out an EIA of its own projects. The court said the requirement had been lawfully transposed in the EIA regulations, but that the proposed handling arrangements to ensure adequate independence had not been done properly and needed to be amended. The inquiry, I think I'm right in saying that the inquiry for the Holocaust Memorial has been held remotely on MS Teams, I think, and a decision is awaited on that. It's a very interesting scheme. Be very interesting to see what the Secretary of State does with its own application. So I think they're the cases we wanted to talk about.
Yeah, thanks, Matthew. We're at the end of our time, and thanks everyone for joining us. It's really good to have such a large audience, and I hope that you'll have good 2021s and don't have to engage with any of the more headache-inducing cases. If you've got any queries on the cases that we have discussed this morning, then feel free to get in touch with Matthew or me, and I'm sure we'd be glad to field any questions that we haven't managed to deal with this morning. But thanks again for joining us, and take care.